you all very much. I appreciate the friends and colleagues on the panel and you for being here today. This is going to be interesting. The response to my book, which just came out, it was released just last week. It's called The Economics of Peace, Freedom, the Golden Rule, and the Broadening Prosperity, has already received a pretty big reaction from the community. It's something that is projecting out 50 years, 100 years into the future. And there's other books that project out, but this is interesting. It has to do with economics and also the judicial system. Epic Change, the Evolution of the Legal Profession. That's quite a lofty title if I ever heard one, and I think it's very apt for what we're going to speak about today. The things I'm speaking about are build perhaps on what the other two panelists are going to speak on, but they are ideas that were conceived over the last few years and are incorporated into the book. The role of the judiciary in a new paradigm. What is that new paradigm? And we'll talk about that. How is the judiciary responding to that new paradigm? And one more question, what is the role of ethics in the new judiciary? The judiciary has changed over thousands of years, the last 100 years, 150 years, even the last decades, and we'll kind of chronicle that as we go. As Larry said, I'm Executive Director of International Cities of Peace, and we have 100 communities around the world, Los Angeles, Nepal, all different areas. Basically, it's a community self-defining themselves and working with their local government, doing resolutions, proclamations to create a culture of peace in their society, peace building. There are women starting businesses in Burundi. There's a group of women who have been raped and ostracized, and they gathered together. There's about 50 of them, and we've been sort of helping them out. But we asked them to start a business, and their business plan came through, and it's 8 goats to end poverty. That was the business, and so now they have 6 goats at this point, and they're building a business, and so that's the kind of peace building that we're talking about: safety, prosperity, and quality of life. There's another interesting thing that happened over the last few weeks. A City of Peace in Arizona wanted to work with a City of Peace in Africa. And they said, is there perhaps a Rotary that our Rotary can work with their Rotary? And to tell you the truth, I didn't know there was even a Rotary in Democratic Republic of Congo. 5.7 million people have been killed over the last 15 years or so. But there was a Rotary in this particular area, this City of Peace. So we asked the leader of the City of Peace in Kawalzi, Democratic Republic of Congo, to get with their Rotary. And so they had a meeting, and it was a big deal because this is the first time, the tribal situation is very, very complex. And so the head, the tribal chief, who's the head of their government, actually came to the meeting. And when they presented their plan for building a school for orphans, they have 100 orphans in their area. The chief gave them 10 acres of land and 10,000 blocks to build a school. And what he said was that there can be no development without peace, and that's a quote from the chief. And I would add, there can be no peace without rule of law, and there can be no rule of law without ethics. So how does ethics play in the judicial system, and what is this new paradigm that we're entering? There's terms about jurisprudence, which you're more familiar with than I, mechanical jurisprudence and sociological jurisprudence, rule by strict letter of the law. It's more complicated than that, but that's a good term, mechanical jurisprudence, and sociological jurisprudence, where we consider the legal, ramification, the social effects, how it affects both clients, the community, the country, the world in general. So sociological jurisprudence brings all of these different facets in and considers the sociological insights. New practices are forming, and they're not actually new. They're decades old, but they're now coming to fruition, and that's collaborative law. Mediation's been around for a long time. Family law, private law, transformative law, restorative justice, arbitration, these participation agreements. I'm not going to speak to those because we have experts on the panel today. But I told a friend of mine who's a judge in Ohio about my book and about some of the implications it has for the judicial system. And he was very excited about it because he's very much into the idea of transformative and collaborative law. And he was actually speaking to the University of Dayton Law School about incorporating some classes into their program. And I was on the phone with him, and I heard him kind of chittering, kind of laughing a little bit on the other side of the phone. I said, "What are you laughing about?" He says, "Well, the only problem with that is lawyers love to fight." So, that's part of it. That's part of it. It's a hallowed tradition that there's, two Goliaths meeting in the courtroom and settling, and the chips fall where they may, and justice is preserved. So, but there's another aspect of law that everyone practices practices today, and that's more empathy, more compassion, more engagement with the clients. And this is not something that anyone here is unfamiliar with. You understand that you have to understand the situation, the sociological implications. So there's a shift. A historical shift is upon us. The idea of an evolution in the judiciary is not new, of course, and for the next couple of slides, I'm going to kind of lay out to remind us of something you may not need to be reminded of, but there has been a historical shift going on for many, many, many centuries and thousands of years. One good thing to point out is this is the old Supreme Court where they met in the old City Hall in Philadelphia, and there were 6 members at the time. There was 2/3 a majority, can you imagine that? And they were then just simply called judges, not justices. And all of those were changed by congressional and executive actions over the years. So the court system has evolved, FDR, there's a lot of history involved in that, but the historical change has gone on, and now there's new faces. The Supreme Court has a new face, and these new faces are not just appearing at the Supreme Court level, but also in terms of the local jurisdictions, federal bench, everything. Sotomayor, Ginsburg, and Kagan are the most obvious ways that the Supreme Court has changed diversity, affirmative action, changing socioeconomic conditions. All of these things are evolving the court as we speak, and they will evolve the court for the next 20 years and 50 years and 100 years. So what is that change going to be, and how is it going to, I'm sorry, I got to click 2 times. But anyway, this is a changing face of the court, and it's local level all the way up, international level also. The historical evolution of the judiciary can be logged in congressional actions. 1787, the Constitution created the judicial branch, and then soon after that, 1783, Marbury versus Madison, that's an incorrect date, by the way. John Marshall established the Supreme Court. The judicial branch is equal to the other 2 branches. 1891, establishment of the Circuit Court of Appeals. 78, the establishment of the bankruptcy courts. 82, establishment of the Federal Circuit. All of this is showing that the court system is evolving, it has evolved, and it will evolve in the future. The judicial system has changed every aspect of our life. You and I and everyone out there, as you look at these, you'll reflect on court cases that had a huge impact on the environment, democracy, intellectual property, both at home and around the world, end of life, national security, public airwaves. All of these have epic changes involved in the cases themselves. Faith, healthcare, and as we all have learned over the last couple of months, immigration. Where will the immigration ideas end up? It'll end up in court, and the judiciary will clarify. So all of these changes show an evolving judiciary, and the responsibility of the judiciary has grown over the decades, the last couple of decades in particular. The court filing by the numbers, 56,000 U.S. Court of Appeals filings, 375,000 district court filings, 284,000 civil filings, and the bankruptcy filings are pretty extraordinary, over 1 million bankruptcy filings. So not only has the jurisdiction and the aspects of society have changed for the court, but also the number of cases and the types of cases. If you look at the cases, there's not a huge increase over the last 5 years, 7 years, 10 years. But if you look over the longer period of time, the court cases have risen and risen and risen because of our societal dependence on the court. This is not just national. Sometimes we get Indiana centric, and sometimes we're America-centric and North America-centric, but this is global. This is international in scale. And the proliferation of international courts is astounding. The International Court of Justice, the International Criminal Court, the dispute body for the World Trade Association. You know, these treaties all have case precedent and case law establishing a way for the court system to deal with these international issues. Inter-American Court of Human Rights, it goes on and on, European Court of Justice, European Nuclear Energy Tribunal. The court has also changed in the way international and national aspects are considered. There's a bunch of hybrid courts developing in arbitration courts and regional courts. The emergence of a third generation of criminal courts around the world. The first one, of course, was Nuremberg and Tokyo, and second were the Yugoslav and Rwanda. And the third have been developing for anything that happens around the world that has a national implication and an international implication. There's these hybrid courts developing. Regional courts, European Free Trade Agreement, NAFTA, corporate law in Africa. These are a huge amount of courts being developed as we speak. So the responsibility and the proliferation and the impact of the judiciary is growing and growing and growing. National disputes. This is very instructive to see the docket of the Supreme Court. I don't want to focus on the Supreme Court because the local level is where most of the action is taking place, but the Supreme Court, what they consider each year and the impact that they make on society is pretty astounding. In 2013, the Fourth Amendment, police dogs finding drugs, the Foreign Intelligence Surveillance Act, the Defense of Marriage Act, voting rights, voter ID laws, affirmative action, generic drugs, gene patents, DNA evidence. Isn't that amazing what kind of decisions are being made in the judiciary now? And these are definitive decisions that impact everyone. And my next slide is something that's not quite as epic. We have epic polarization, and we have legislative action by the numbers. There are 10,238 bills before Congress, and of those, usually only about 5% become laws. However, the 113th Congress, as we know, has been a little more hesitant in doing too much. So there's only 2% laws that they will pass, 184. And one of them was to designate the facility of the U.S. Post Office in New York as the Christopher Scott Post Office building. I have nothing against Christopher Scott, but that's one of the things that they accomplished. So what is happening? What is that? What implication does that have for the judiciary? The necessity of just governance. That's what we're speaking of today. There's a responsibility of proliferation, and there's an actual necessity for making a transition to a new paradigm, a new shift. In a more just society, historically, there's two key components. One, prevention of accumulated power. It's in the Declaration of Independence, it's in Magna Carta, it's in Constitution, Bill of Rights. we're sort of against somebody holding their own over us, and that's what a lot of the components for a just economy and society is. The second one, however, is fairly new. The idea of an economic necessity, the ability to adapt to rapid change from innovation. Now, you don't think about this much, but it's very, very important, and the implication has to do with why these experts on this panel have something to say, and that's how do we function with this kind of economy that's coming upon us. And you all might be familiar with this book, Jeremy Rifkin, The Third Industrial Revolution. It's a great book. He projects 50 years out into the future, what society is going to become, energy focus mainly, but I'd like to read a paragraph of his. Intelligent technology is only just beginning to impact the world economy. In the next several decades, tens of millions of workers across every industry and sector are likely going to be displaced by machine intelligence. Ray Kurzweil of MIT observes that the pace of change of our human-created technology is accelerating, and its powers are expanding at an exponential rate. Kurzweil calculates that at the current rate of technology, by the end of the 21st century, we will witness on the order of 20,000 years of progress, or about 1,000 times greater than what we achieved in the last century. Or to put it another way, because we're doubling the rate of progress every decade, we are likely to experience the equivalent of a century of progress in 25 calendar days. So this is a little bit into the future. It's happening right now, and if you're in technology, you're more aware of it. But in 25 days, a century of progress. That's not 25 months or years. That's 25 days, a century of progress. Now, with that kind of technological advancement, that kind of change in the economy, Apple, Samsung, Honeywell, every single company out there is experiencing this kind of rapid change, and they need the way cleared. And so they're relying on the courts to do that. So with this kind of change, the necessity of judicial governance and for the attorneys and judges to really embrace the idea that you're going to have to grapple with that kind of change in the future means that what this panel is speaking of is a way forward. And there's many ways forward, but this is definitely one of them. This is a new paradigm that we're entering today. So why is the judiciary best able to ensure these needs? The role of the judiciary, based in finding justice, is expanding in response to the needs of society. The legislative and executive bodies of the nation states move society forward by agendas. That's what they do. They get together, they compromise, they Democrat, Republican, Independent, they get together, they figure out an agenda, and they further that. The judiciary is different. There is agenda. I'm not saying the judiciary is without problems. Matter of fact, there's a lot of problems. We know that. But the judiciary is based in justice. These discrete court cases build a governance system that is based primarily in justice. That's why you're there. So it's a different sort of situation from the other two branches of government. Based in justice. Justice means a more peaceful society, more equitable society. The new relational economy is a freely flowing system requiring the evolution of the way we settle the natural conflicts that are part of rapidly changing economic life. This is a relational economy where Apple gets together with Microsoft, and they build relations, and we bomb Vietnam, and then we're a trading partner of Vietnam. These are the relationships that need to be cleared away by the judiciary. With that kind of astounding change, 100 years in 25 days, the macro view of the legislative and executive branches are not capable of being able to do that. Only the judiciary is capable of being able to respond to those kinds of rapid changes. And that's why the local judiciary is so important, because that's where it starts and that's where the progression is made, the appellate courts, etc. The world's current governing system are institutional rather than relational. They're bureaucratic in nature. They're agenda-driven rather than justice-driven. Money and power have a great deal to do with it. The macro as opposed to the micro. They're amoral rather than moral. We have a separation of church and state, thank goodness, as far as I'm concerned. But we also have a separation of state and ethics at this point. Do we have a separation of the judiciary and ethics? I'm not sure about that, but what I'm presenting today is about the golden rule, and the golden rule is not the golden rule you learned in first grade. The golden rule is a very deep and profound ethical foundation, and that's what we're going to speak to for. I'm not going to spend too much time on this because you know more than I do about this. The administration of the function of the judiciary, administration of justice, that's a basic function, judicial functions, guardianship of the Constitution, advisory jurisdiction, protector of fundamental human rights, supervisory functions, non-judicial function, administration of property, and some minor children, etc. The seventh one, the lawmaking function, is the most controversial and the most tightly held function of the judiciary. When existing laws are ambiguous or conflicting, judges can rule or make new law. There's a lot of conflicting and ambiguous laws out there that need to be clarified and moved forward in order for the relational economy to function. Most of the organizations that I interviewed for my book have been to court because they need to clear the way for what they want to do, for these innovative ideas. They need to clear the way, and they go to courts to do that. They don't go to Congress to do that because Congress would take years to do that if they did it at all. The judiciary is where this is functioned. Lawmaking functions, I believe, are going to expand. Now, what do I mean by judicial governance? I've been throwing around that term quite a bit. Judiciary's mission is based in finding justice. A growing global network of courts and judges supported by collaborative and integrative and transformative law innovations are settling disputes, adjudicating cases, and making new laws based on a relational approach to governing. The principles of judicial governance, I believe, are case law with precedent, equal access to law, democracy, and just enforcement. And those have parallels in the Golden Rule. A moral judicial governance system is simply one that allows the natural ethics of the Golden Rule to be expressed. And I know this is a little bit out there, but we'll try to chop it down into something that makes some more sense to you. How is the judiciary responding to all these needs? The idea of this rapid change, the idea of the proliferation of courts and the necessity, the rule of law in Nigeria, the rule of law in Nepal, all these different areas. This is an international thing about. The rule of law is evolving and responding with a historical shift in consciousness. And that consciousness has evolved over the thousands of years period. This is a progression of societal rule. Back in the prehistory, Egyptian ages, there was a guy on a throne, and people would bring a dispute to them, and they would rule, and then they would go about their business, and that was the golden staff. And the best example of that is Solomon, where the two women bring the baby to Solomon, lay it at the feet, and they say, it's mine, it's mine. Well, Solomon, in his infinite wisdom, tells the guard to cut the baby in half, and then give one half to one woman and one half to the other. And then one of the women started crying. And so he knew at that point, in his infinite wisdom, that it was that woman's baby, and he gave it to her. So wouldn't it be great if everything was that easy? But as we moved along, that's fair justice. It started thousands of years ago, fair justice. Our consciousness moved into the golden mean, and that's the Greco-Roman era, the legalistic era, where we have blind justice, and we have Lady Justice with the blindfold and the scales, and weighing the basis of fact and determining a decision. So the best we can achieve at that point is blind justice. Now, during the Enlightenment phase, which was part of my preparation and my studies, there was a shift going on in the Enlightenment. And there's many, many reasons for that. It's very complicated, but the Enlightenment entered a new age. It was a relational age, humanistic age. So now we have the Constitution, we have the revolutions, and we have a huge shift in human consciousness happening. And the 14th Amendment is what I use as an example, due process. We have equal justice at this point. I think we're moving even further into a shift. We're not immune to this 25-day advancement of 100 years. So what is the next shift? And that's what some of my colleagues are going to be speaking about. Sorry about that. I keep getting out of sync on this, but this is in your book, but it's a progression of societal rule. The golden staff to the golden mean to the golden rule. So what is this golden rule? Do unto others as you would have them do unto you. That's what everybody speaks to. It is an ancient philosophy that we have learned and we have inside us, whether it's genetic or whether it's Richard Dawkins' memes, of cultural memes, but we have retained the golden rule as a basic foundation for ethics throughout thousands and thousands of years. And just so I can give a promo to my new book, I'll give you just a little bit of a description of the golden rule. I did 2 years of study on the golden rule, and it doesn't seem like, the way we think of the golden rule, it doesn't seem that the golden rule would take 2 years of your life, but it's actually very, very complicated, and it's very, very profound. So the golden rule gives us the basis not only for morality, but also for natural law, or a sense of right action derived from nature. As humans, we try to understand the roots of ethical reasoning for our most basic actions. We develop norms of behavior for the treatment of ourselves and thereby for the treatment of others. Golden rule reciprocity provides the fundamental reasoning for human rights and the language of our democratic constitutions. Equity, fairness, and goodness fall out of mutual exchange, and the golden rule's subjective-objective analysis. The golden rule is a physical, emotional, and spiritual force that helps us find right action. We move from egotism through sympathy to compassion. We transcend from simple self-interested response to taking action based on a moral foundation. And it's in every religion. If you go through, especially the Baha'i religion has a chart, all the different religions, Buddhism, Sikhism, all the religions have a golden rule, and it's very specific. One of the great stories of it, Rabbi Hillel, which is a very famous, important person in Jewish history, was asked a question by it sounds like a taunter, actually, but said, "Teach me the whole law at once," he was asked. And Rabbi Hillel said, "That which you hate, do not do to your neighbor. That is the whole Torah." While the rest is simply commentary. So the golden rule is not only the basis, it is the moral foundation for human rights and religions and everything else. Why we don't have it taught in our schools? That's why we're forming the Golden Rule Institute. But the golden rule is the moral foundation of justice. It's survived the centuries. The golden rule ethic, this is my creation, so you don't have to believe it. But there's 4 processes for the golden rule. One is empathy, one is compassion, one is engagement, and one is unity. And those are progression. Empathy, we become aware of the other. Compassion, we move from empathy to a strong identification with the other's feelings. That's compassion. Engagement, from that compassionate desire to help them, help us, we move to reciprocal engagement of right action. And then from that action, we develop a sense of unity, not only with who we're dealing with, but also with the world. So from compassion and engagement, we begin to lose the separation we originally felt to the other. And basically, we're all in this together. That's as simple as that. Now, all four of these have parallels in the judicial system, and I believe that all four of them have parallels in every single case that and dispute that you will encounter. The four principles of judicial governance system surrounding Golden Rule: case law and precedent, equal access to law, democratic judiciary, don't throw anything, and fair enforcement. The Golden Rule imperatives expressed for societal control and direction. Empathy leads you to want to understand the situation. You have to understand, the both parties in the dispute, and that's something that every single dispute, the process occurs in every single dispute that you encounter. Compassion activates our desire for justice, justice for them, justice for all, which is ensured by equal access to law, and the judiciary has, well planned out appeals courts, etc. Third is engagement, our ability to govern ourselves. We have to take responsibility. That's a big part of it. Engagement, you take responsibility for your actions, and the other party takes responsibility for their actions. And unity, it activates our consent to be governed. In our society, there are many who feel that it's unfair. They feel that money and power rule. The little guy doesn't get a chance, and basically the lack of consent to be governed is a huge problem in society. The unity is what gives us the consent to be governed. So how does this apply in a judicial case? So I have a case that we'll describe it on kind of a global schedule, but you can take any case and apply this. This is the United States District Court for the Western District of Washington, Cetacean Research, which is a Japanese whaling company, against Sea Shepherd Conservation Society. And many of you will remember Captain Paul Watson from cable TV, and he's the one that rammed whaling vessels. The humpback whales reached a nadir of about 5,000 a couple of decades ago. And the International Whaling Commission adopted a moratorium on commercial whaling, but left a scientific research caveat, and the Japanese used that to basically continue their whaling activities. Paul Watson, problem sort of guy, he started ramming the whaling vessels. So Interpol, Costa Rica, asked Interpol to issue a red notice. Watson was arrested. He went to Germany, stayed in jail. He was released on bail, and then he left, and he spent 15 months at sea, a man without a country. So Cetacean Research brought a suit for injunction and damages. Seattle Court District ruled actually the first time in favor of Watson. Watson returned to the U.S. Customs did not arrest him. Ninth Circuit reversed, and the judge actually in his statement branded Watson as a pirate. So that's ongoing. The current International Court of Justice ruled that Japan had breached the convention. Interpol dropped the red notice. Watson filed a motion to dismiss the claims as moot and unripe. That was denied, but the suit is ongoing. So the humpback whales over this time have now reached 80,000. So, what does the Golden Rule have to do with that? It's not easy to take a look at that and apply the Golden Rule to it. But empathy. Empathy for others leads to the search for understanding of the situation, the sociological jurisprudence. The public opinion against whaling was huge. The needs of both parties were considered. The case law, the 1971 Pelley Amendment to the Fishermen's Protective Act provide case law to further the understanding so that people could rule on it in the court system. Compassion activates our desire for justice, which ensures equal access to law. Both parties had equal access to the law, not only in the United States, but also around the world. The global court system, Interpol, the national courts, international courts, district court, appeals court. That's basically equal rights, equal access to law. The engagement activates our ability to govern ourselves. The disputants are responsible for their actions, both parties. This is the global democratic ideal that is inherent in rule of law. The International Trade Court ruled against Japan. The U.S. District and federal courts stopped the piracy of both parties. And in the unity, it activated our consent to be governed. We all consider that as fair, and we apply it to other environmental cases. Watson was allowed to return to the U.S. The Canadian government just last Friday reduced the humpback whale status to from threatened to just special concern. So this is the judicial court system in action. This is empathy and compassion, engagement, and unity. We see it in these kind of high-profile cases, but it's also in local court cases, every single local court case, to one degree or another. 4 principles. I think I'm running out of time, so I'm going to skip through this. These are, more description of each of these 4 principles of a governing system. The legal, first of all, you have the proliferation of courts. Second, you have increased responsibility of courts. Then you have this sociological shift going on in society, this global consciousness, the idea of us not being able to tap the idea of ethics, because ethics has sort of been separated from the public view. So the legal profession is responding in a number of ways. It's rapidly evolving with innovations that resolve conflicts by golden rule transformative processes. Right now, if it wasn't for cases being settled out of court, cases being settled through mediators, there's community mediation going on, there's transformative processes all over the world, sometimes even more than in the United States. Collaborative law, integrative law, transformative law, all of these things I'm not going to go into because we have people that have greater expertise on the panel. But this is a solution. This is the solution to a paradigm shift that we're experiencing right now. It has to do with economics, has to do with the governing system. The problems are huge. Litigation too expensive, costs prevent equal access, caseload increases, complexity of cases is astounding. The democratic elections are a huge problem. Politicizing the cases, the rise of the the rule of law the world over. In my capacity as International Cities of Peace Director, I speak every single day to people in countries that are just beginning to develop rule of law, and they're begging for it. And they're begging for this idea of a transformative, holistic method of solving conflicts, and they're looking to America, and they're looking to Indiana, and they're looking to you. Transnational cases, increase in international cases, data security and privacy, these are all huge, huge problems. How is the judiciary responding? This is just one attempt that there's no particular reason why this is here other than to show that there are attempts being made to evolve the judiciary. This is the Institute for the Advancement of the American Legal System, Trial Lawyers Task Force. They deal with 29 proposals to evolve the judiciary. Civil procedure, fact-based pleadings, discovery, expert reports. They're offering suggestions to evolve the judiciary, make it more efficient, more just. Whether those are good rules or bad rules, you would know more than I. But there are people who are evolving the judiciary. Now, how will the judiciary evolve to solve these inherent problems? How will the judiciary step up to the increased responsibility of governance, not just dispute resolution or understanding how to keep a level head in society? This is governance. This is actual governance. Who will provide for the theoretical foundation required for the next evolution of the judiciary? Where are the John Marshalls? Where are the William O. Douglases? They're in this room. They're on this panel. They're in the audience and video. This is our time. Peace is the zeitgeist of our times. It's the way the world is beginning to think that peace is a part of society, and rule of law is such a huge part of that. There's one section in my book that I'd like to read about that. The judiciary branch, as noted, is tasked with pursuing equal justice. The judiciary's core function is therefore justice-based, as courts rule disputes by weighing circumstances and evidence, then rendering decisions that form case law and new precedent. On the contrary, the core function of the judiciary, or the legislative and executive branches, are necessarily agenda-based to control and direct society through statutory laws and administrative rules. With its limited ability to change or create laws through discrete court cases, the judiciary has expanded its power and jurisdiction to new areas of law. The judiciary is better able to respond objectively to conditions required by a relational economy based on innovative change. General codified laws by legislative and executive actions restrict the ability of the economy to adapt quickly and are subject to powerful influences that seek external control. The ability of the judiciary to create law is reserved mainly for common law jurisdictions, where it can apply equitable principles in cases where statutes fall short. In judicial governance system, the court's ability to apply equitable principles would allow for the evolution of historically legislated administered laws that are bogged down in bureaucracy and agendas. With an evolving ability to adapt statutory laws and provide enforcement under the domain of a democratically elected judiciary, the need for legislative and executive bodies would be drastically reduced. A judicial governance system does not entail a revolution, but simply an evolution of governance system, evolution of governance based on relational justice and the institutional use of the golden rule reciprocal ethic. New theories and expansion of the standard and appellate court systems, as well as alternative methods such as collaborative law and private law, are needed to handle the increase in caseload and responsibilities that will come from changing economic activity and the demand for governance to reflect justice. Thank you very much.